June 15, 2018 will go down in history as the day that the constitutional promise of religious freedom was betrayed. In the next few minutes, I will explain why.
Intersection, a discussion on current issues involving law and religion with your host, Barry Bussey.
The Supreme Court of Canada released two decisions against Trinity Western University's bid to have a law school, one involving the Law Society of British Columbia and the other involving the Law Society of Upper Canada, which is now the Law Society of Ontario. Simply put, they disrupted our understanding of the accommodation of religion in a dramatic way. Trinity requires students to sign a community covenant saying that they will respect the school's religious teachings, including the requirement that sexual relations be kept within the traditional marriage relationship of one man and one woman. That, the Law Society said, was discriminatory, and they refused to accredit Trinity's law school on that basis. In its decisions, the Supreme Court ruled by a vote of 7-2 that the Law Society's decisions were reasonable. However, I take the position that the Supreme Court's decisions were themselves unreasonable and a harbinger for serious religious disputes to come. First, the Law Societies have no statutory authority to investigate the admissions policies of law schools. This was pointed out by Justice Cote and Brown in their dissent. They criticized the 7-member majority of the court by noting that a law society is, quote, not a roving, free-floating agent of the state. It cannot take it upon itself to police such matters when they lie beyond its mandate, end quote. Now, it is important to keep in mind that there has been no challenge to the academic caliber of Trinity's proposed program. Their curriculum is exemplary and innovative, and its focus on charity law would have addressed a void in legal education across the country. Plus, its practical emphasis on justice for the marginalized and impoverished seems a far cry from the critics' depiction of Trinity as harmful or degrading. As far as the program itself is concerned, there was and is no legitimate concern or objection to accrediting Trinity's law school. But that did not worry the court majority, since in their view, the law societies were operating in the public interest. The court expanded on the term public interest to allow the law societies to pass judgment on the religious beliefs and practices of Trinity. The court said that being in the public interest, the law societies were entitled to promote equality by ensuring that there was equal access to the profession and by supporting diversity and preventing harm to the LGBTQ law students, as they defined it. Now, this was justified, said the court, because when the government administrative authorities carry out their work, they must not only be concerned about charter rights, but also charter values in implementing their statutory authority. Now, charter values have become a familiar term over recent months with the current Canadian government's Canada Summer Jobs program. You'll remember that the government is requiring applicants to agree with the concept of charter values in order to be granted funding. Now, in this case, the Supreme Court has now ruled that charter values are, quote, accepted principles of constitutional interpretation, end quote. This is a worrying development, and here's why. Charter values are very subjective. Justices Cote and Brown explained that charter values have no source but the judge making the decision. A charter right is written in the charter, but the concept of values is undefined. And here's what Cote and Brown had to say about charter values. They said they are, quote, entirely the product of the idiosyncrasies of the judicial mind that pronounces them to be so, end quote. And one judge will have a very different set of values than another, and those values may or may not be shared by all Canadians. This, in and of itself, said Cote and Brown, as I quote, should call into question the legitimacy of judges or other state actors pronouncing certain values to be shared, end quote. This ruling is therefore a real problem. With this decision, government decision makers have acquired greater latitude to apply their own understanding of what charter values mean. But it gets worse. As Cote and Brown explain, these so-called values limit, quote, constitutionally protected rights, end quote. Now notice the absurdity of what is happening. Charter values, which are not constitutionally written anywhere, but exist only in the mind of a judge, are used as justification to limit constitutionally protected rights that are written in the Charter itself. Applied to this case, we see that Trinity has a constitutionally protected right to religious freedom. This right allowed them to run their university in accordance with their religious beliefs. In 2001, the Supreme Court of Canada agreed that Trinity Western had that right. However, today, the same court has ruled that charter values of equality are sufficient to limit religious freedom. And to be clear, these decisions do not say that Trinity has done anything unlawful. As Justices Cote and Brown point out, the majority ruling is really a subjective, and I'm quoting from them now, quote, moral judgment, end quote, rather than a legal one. It is truly a sad decision for the rule of law in this country. This court did not like the religious practices of Trinity when it comes to marriage, plain and simple, and then took away their right of religious freedom. The court is now sanctioning the use of the Charter as a sword rather than a shield. The court is now saying that the state can enforce its own views on the religious opinions of others. And as I will discuss later, this is now a case where the court is sanctioning the state to go on a secularizing mission to ensure that religious enterprises are in compliance with government views of charter values. Folks, we are entering uncharted territory. Justice Cote and Brown also noted that charter values are amorphous and undefined. Listen to what they said. Quote, charter values like equality, justice, and dignity become mere rhetorical devices by which courts can give priority to particular moral judgments under the guise of undefined values over other values and over charter rights themselves, end quote. Cote and Brown criticized the majority's use of the term equality, noting that the majority does not and cannot point to a specific legal rule or right to ground the equality value in this case. In ominous language, they noted that, quote, equality in an absolute sense is also perfectly compatible with a totalitarian state being easier to impose where freedom is limited, end quote. Second, the majority decision did not make any statement about the fact that Trinity is not subject to the Charter. That is, Trinity is not a government actor. The Charter only applies to government as it protects us as citizens from government violation of our rights and freedoms. This basic constitutional fact was not at all considered by the court majority. Yet, there was a major point in the Trinity Western 2001 case at the Supreme Court. The silence of the 2018 court on this point is deafening. By the way, the court did not specifically state that the 2001 case involving Trinity was overturned. They by and large ignored it, or the legal speak would be they distinguished it. This is a court that is not afraid to overturn previous decisions. For example, in the euthanasia debate, the court overturned its Rodriguez decision of the 1990s when it gave its recent Carter decision, making medical assistance in dying legal in Canada. Thus, it is not surprising in one sense. There was very little regard for its 2001 decision on Trinity, which was very similar to the current case. In 2001, the Supreme Court dealt with the education degree at Trinity Western when it allowed Trinity to be accredited. In this current Trinity case, it was the law degree that needed accreditation, but of course that is now rejected. The principle of the court being bound by previous decisions is now a legal doctrine of the past, as the court is becoming more and more influenced by politics. Third, the court majority said that when balancing equality rights and religious freedom, equality in the most abstract sense won out. The court claimed that if Trinity were granted accreditation, then, quote, the public confidence in the administration of justice may be undermined if the Law Society of BC is seen to approve a law school that effectively bars many LGBTQ people from attending, end quote. They noted that, quote, being required by someone else's religious beliefs to behave contrary to one's sexual identity is degrading and respectful. Being required to do so offends the public perception that freedom of religion includes freedom from religion, end quote. Now, Justice Cote and Brown rejected that analysis, noting that, quote, the role of courts in these cases is not to produce social consensus, but to protect the democratic commitment to live together in peace, end quote. The position of the court majority truly is baffling, especially since attendance at Trinity is voluntary. No one is forced to abide by the covenant unless they voluntarily choose to apply and attend Trinity. Trinity is a religious university. It's not a public university. Being religious, it is only natural that it would have religious rules that it expects its students and faculty to abide by. The court is in effect saying, look, you Christians can't require us to accept your views of sexuality, even in private religious institutions, but we, the courts, we, the government actors, can make you follow our views, and that is totally fine. Folks, this is simply implausible, and certainly not the way that Canada we have known until now. Have we ever been accustomed to this? The court majority took exception to Trinity's claim that religious freedom includes the right to enforce non-believers to follow the community covenant while they are students. It now appears that the court is of the view that religious freedom does not include the right to require its beliefs and practices be complied with by those non-believers who choose to attend Trinity. However, that raises a real problem, as religious organizations, by their very nature, require those who want to be part of the community that they must follow its rules. Indeed, over the last number of years, the Supreme Court has said that it cannot get involved in the religious affairs or the internal religious affairs of churches. Only a few weeks before it released the Trinity School of Law decision, the Supreme Court said in the Jehovah's Witnesses case that courts cannot interfere in the internal religious decisions and rules of churches. However, in this law school case, the court has done just that. They waded headlong into the theological issues by weighing what is or is not part of Christian practice, essentially claiming, even though you, Trinity, say your community covenant is part of your biblically based beliefs, we disagree. And you cannot enforce it on the non-believers. What is the rational explanation for this contradiction between the Wall case of just a few weeks ago and the Trinity Western Law School case today? Now, in the Nova Scotia Supreme Court, Justice Jamie S. Campbell said that the Charter is not a blueprint for moral conformity. He ruled against the Law Society's treatment of Trinity because he said that the state does not have a secularizing mission. It is not to go around requiring religious entities to take on the worldviews and morals of the government. There can be legitimate differences of opinion and practices, and that is okay. However, now, the Supreme Court of Canada has said the opposite. It does appear that the state can secularize all religious entities that are in the public square that does not accept its view of the world. That is very troubling. Here is the crux of the matter. How can we live in peace together while maintaining our differences of opinion and practices on fundamental human life issues, such as marriage, abortion, and end of life? Religious communities, by their very nature, speak to these issues and more. Religions are concerned about the human project, which involves deep understandings of culture. The court majority talked about diversity, but did so in a manner that excludes the religiously committed from the public square. There is a double speak going on. They are using diversity language, all the while excluding Christians. That is not diversity. That is a denial of the Constitution's protection. Canada has traditionally been a country that is multicultural and plural, where many different groups are able to grow and flourish. The majority decision did not directly say so, but it has implicitly rejected the Trinity Western 2001 decision of the court that championed diversity. Back then, a mere 17 years ago, the court was of the view that multiple religious organizations mark our societal landscape and that such diversity of views should be respected. That was then. This is now. After these two decisions, we are left with a very different understanding of Canada. Now, even though the Charter does not apply to religious organizations, it does apply indirectly through the use of Charter values language. That concept of indirect applicability was hinted at by Justice Rowe in the Jehovah's Witnesses case a few weeks ago, and I made mention of it in my last intersection video. Our national court has elevated the offense mantra of identity politics to a Charter value which is on par with a Charter right. The long-term implications of this case will now be played out in the coming months and years as various groups who find religion offensive will use these cases as a template for further attacks against religious entities. However, this is indeed a different day, a different time. A time when we must wonder what's next. What other public license or approval does a religious charity require from the government that allows the charity to carry out its work in the public square? I can think of some. For example, how about registered charitable status, which was hinted at in oral argument by the Canadian Bar Association's lawyer? How about licensing of religious or accrediting religious elementary and high schools? And then, of course, universities. Universities that have nursing schools, schools of business, and education degree programs. And then how about nursing homes? Or what about building permits for construction? Are we now going to be in a place where a municipality can say, hold on here now, this church has discriminatory policies, and if we give building permits to them, we would in essence be condoning their discrimination. That seems far-fetched, but I don't know. Daycare centers, summer camps. I mean, already, even before these decisions, the Canadian government took a similar view with the issuing of summer jobs grants. every indication is that we are at a cultural moment where religious bodies are being pressured to leave the public square. Only totalitarian states have done that. In short, every government bureaucracy or agency has now been given the green light to review who they give government benefits or programs or licenses or accreditation to based on the amorphous and ill-defined concept of charter values. A concept that has been shown to take away a right that has been inscribed in the charter itself. The former Chief Justice even stated that had Trinity been given the accreditation, then the law societies, or in the case of the British Columbia Law Society, would have been condoning the discrimination. This is simply not so. As Justices Cote and Brown noted, it would have been instead accommodating religious freedom, not discrimination. I quote, "By accommodating diverse beliefs and values, the state protects and promotes the charter rights of all Canadians," end quote. Instead of accommodating the rights of all Canadians, the Supreme Court has now put the rights of all Canadians under a precarious position. Rights are now subject to charter values, being, as Justice Cote and Brown noted, the idiosyncrasies of the judicial mind, end quote. That does not bode well for freedom in this country. And today, it is religious freedom that has been taken away. We, religious and non-religious alike, have every reason to be concerned. This case will be discussed and debated for years to come. I hope that this ruling is the low point of charter jurisprudence dealing with the troubling concept of charter values. But given the resolve of this court to maintain this disturbing concept, we are bound to suffer more loss of freedom than ever before. This is only the beginning of a very different chapter on religious freedom than we have experienced in this country to date. Justices Cote and Brown stated that the method by which the court came to its conclusions, quote, betrays the promise of our Constitution, end quote. I have nothing to add to that. These cases certainly were a betrayal of our Constitution's promise to protect religious freedom. Stay tuned. This story is not over yet, not by a long shot. Our resolve to correct this injustice continues.
You have been watching Intersection, a current affairs program on law and religion. We invite you to learn more about this topic by subscribing to Barry's blog at lawandreligion.org.